My name is Jonathan Eskow, and I'm the founder of Eskow Law Group, a boutique law firm that works exclusively with healthcare companies and providers. The topic of this short video is the new beneficial ownership information reporting requirements that are part of the Corporate Transparency Act that was passed into law as of January 1, 2024. Before we get into what this means for you, it might be helpful to understand a bit more about the act itself. It was adopted by the U.S. Department of the Treasury's Financial Crimes Enforcement Network, FinCEN for short. And the goal of the new reporting requirements is to help the U.S. identify the beneficial owners of legal entities. For the purposes of this conversation, when I refer to legal entities, what I mean is different types of entities, such as corporations, limited liability companies, and partnerships that are actually filed with a state. The act was deemed necessary because there were a bunch of financial crimes committed over the years by faceless legal entities where law enforcement had trouble determining what specific individual or individuals were actually behind the crime. This made both the investigation of alleged crimes challenging, as well as the actual enforcement of laws and the prosecution of those crimes as well. The reason this became an issue, though, is because when a legal entity gets filed with a state, it is possible to fully or partially, depending on which state the entity is filed in, hide or shield certain personally identifiable information. In order to help get a handle on this situation, and because there's really no easy way to distinguish between the few legal entities that actually commit crimes and the vast majority of legal entities that don't commit crimes and are existing for fully valid legal purposes, the rule needed to be applicable generally to all legal entities, with some defined exceptions, which we can get into in a second. With that background in mind, I thought it might be helpful to do a very simple who, what, where, when, and why, so that you have the broad strokes overview on what's going on. Small disclaimer, this video is purely for general informational purposes, and if you have more specific questions about your specific legal entity and what needs to happen, we strongly suggest that you reach out to a lawyer or accountant for more specific guidelines. So let's start with the who. These new reporting requirements apply to all legal entities that either 1, employ 20 or less full-time employees, or 2, have reported in their most recent tax return gross sales or receipts of less than $5 million in the previous year. So again, what this law and the reporting requirements apply to are legal entities where 1, there are fewer than 20 employees, full-time employees, and 2, there is the most recent filed tax return shows gross receipts or sales of less than $5 million. Since this only applies to legal entities, if you own your practice as a sole proprietor, which we strongly do not recommend, this new act wouldn't apply to you. Further, there are 23 different exemptions for various types of businesses that don't need to comply with these reporting requirements. But for healthcare companies and practices, they're largely inapplicable. So now that we've covered the who, let's turn to the what. For each applicable legal entity, there needs to be a one-time report filed with the U.S. Department of Treasury detailing the beneficial ownership of the legal entity. So what does that mean? A beneficial owner is defined as a person that either 1, exercises substantial control over the company, or 2, owns or controls at least 25% of the company itself, meaning owning 25% of the shares or equivalent. That one's pretty black and white. The substantial control test, though, is a little bit more ambiguous. What the law entails for a substantial control is that it's either a 1, senior officer, so think a C-level executive, 2, a person who can either appoint or remove a senior officer, 3, an important decision maker for the company's business, financial, or structural aspects, or 4, and this is a catch-all, anyone else who exercises substantial control. So that's the who of who needs to be targeted and reported as a beneficial owner. So now let's deal with the where. For both filing options, the link is https://BOIEfiling.fincen.gov. Make sure you select the Beneficial Ownership Information BOI reporting option and not the Bank Secrecy Act BSA reporting option. You can file this reporting either electronically by submitting the information directly online, or you may complete a PDF form and upload it directly to the FinCEN website. The whole process, if you have the relevant information handy, which includes some form of personal identification, such as a driver's license, it will only take about 5 to 10 minutes to complete for each legal entity. When? This is one that you definitely want to pay attention to because there are some very specific timing parameters to pay attention to. If a legal entity was formed before January 1st, 2024, you have until January 1st, 2025, a full year, to complete the filing obligations. So if it was filed before January 1st, 2024, you have until January 1st, 2025, one full year, to complete the filing obligations. For any legal entity that was formed after January 1st, 2024, but before January 1st, 2025, you have 90 days from the formation of the legal entity to complete the filing obligations. Again, if it's between January 1, 2024 and January 1, 2025, that's when the legal entity was filed. You have 90 days from the date the legal entity was filed to complete the reporting obligations. Lastly, for any entities filed after January 1st, 2025, you have 30 days from the filing of that legal entity to complete your reporting obligations with the FinCEN. If any information in the initial filing changes, for instance, you bring on a partner and there's a new beneficial owner, or you are a partner and you increase, let's say, above that 25% threshold and now you own 40%. In those situations where the reporting requirements change or the information in the initial filing changes, you have 30 days from the date of the change to update or correct the information, and you can do so by going to the same exact link that you went to in order to complete the initial filing. Now for the why. Why do we even care about this? Why are we talking about this? And why should you make sure that you actually complete the reporting obligations? Given the infancy of the Act, the enforcement of these laws are uncertain, both in terms of scope, right? How often they're going to theoretically go after people, right? And the severity. When they do go after people, how hard are they going to come down on people? Now, what's important to know that if it does get enforced, there are both civil and criminal penalties that could apply. So while we don't know exactly the degree to which this law is going to get enforced, because of the presence of those very harsh penalties, we do strongly recommend that everyone complete and comply with the Act's filing requirements as soon as possible. Again, it's really a 5 to 10 minute process for each legal entity, so it's not overly burdensome. And the penalties for not doing so are severe if they actually get enforced. And at this point, we have to assume, because we don't have the background information yet, we have to assume they are going to get enforced. Hopefully this information has been helpful, and thanks for watching. Be sure to subscribe to stay up to date for more great information from Henry Schein.